So welcome to everyone. I'm Professor Larry Helfer. I teach here at the law school, and I'm a co-director of the Center for International and Comparative Law. And I am really delighted and excited to welcome you to this evening's panel discussion, Decriminalizing Homosexuality in India, Love, Law, and the Constitution. This event is part of the Duke Law Human Rights in Practice series organized by the International and Comparative Law Center and the International Human Rights Clinic at Duke Law. We have many co-sponsors who I will mention in just a moment. But I'm really delighted, first and foremost, to welcome to Duke Law two of the attorneys and human rights advocates who represented the petitioners in the successful challenge to Section 377 of the Indian Penal Code, Menaka Guruswamy and Arundhati Katju. Also with us, we're very excited, is Vardhman Kumar, a PhD student at Duke and one of the co-petitioners in this case. All of the panelists are highly accomplished in many different respects, and we decided that rather than my spending 10 minutes telling you why that was the case, we would actually give you a short version, mind you, of their bios in the handout. So I hope you have those with you so you can learn a bit more about the panelists. So the format for this evening will be as follows. Menaka and Arundhati will give a presentation about the litigation that resulted in the path-breaking judgment of the Indian Supreme Court in September of last year. They will, after that, invite Vardhman to answer a few questions. This is, I understand, one of the first times since the litigation they've had an opportunity to reflect with him on what the litigation has meant in terms of its consequences and what it might mean for the future in India and elsewhere. So that'll go on for 30 minutes or so, depending on how the discussion is. We'll then open up to Q&A from all of you. And please, I will recognize you, and we've got two student assistants who have wireless mics. We're recording tonight, so please wait for the wireless mic to get to you. Although we can hear you, those on the recording who'll be listening later or watching later won't be able to. Once we're finished with the discussion, we can go until 7:30 or whenever the Q&A runs out. There will be a reception in the mezzanine outside of this room with food, wine, and beer, and you're, of course, all welcome to join us there. So finally, before turning things over to our panelists, I just would like to thank our many co-sponsors, and please bear with me, this is, I believe, the longest list of co-sponsors I have ever had, at least in the 10 years I've been at Duke, and maybe in any law school event in 20 some odd years of teaching. The Center for Sexual and Gender Diversity, the Department of Asian and Middle Eastern Studies, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Keenan Institute for Ethics, Fuqua Pride, the Human Rights Law Society, the International Law Society, Outlaw, the LGBT student law group, the Program in Gender, Sexuality, and Feminist Studies, Sanford Pride, Sexuality Studies, and the South Asian Law Students Association. So we're really delighted that all of you can be with us, and I'm going to turn things over to Menaka and Arundhati to begin our conversation.
Well, thanks a lot, Professor Helfer, and thank you to Duke, Professor Iyer, Professor Huckabee, and really to all of you for coming out this evening. Before this trip, I last saw Vardhman in July of 2018. And he had flown down. It was a short ride for him, so he flew Raleigh, Newark, Newark, Mumbai, Delhi, to witness a day of the hearings at the Supreme Court. Now, the day, coincidentally, that Vardhman picked was the day that the respondents would argue. So he spent the whole day hearing arguments by multiple respondents who supported the sodomy law staying in place. We're sorry that that's the day you picked. We could have suggested better days. So since July 2018, when we saw him, to now in July 2019, January 2019, the world has changed for so many Indians. And it has changed simply because folks, citizens like Vardhman, believed that it was time for change, that they wanted just a better life. So when I'm asked often, and I was asked today, earlier in the day, in a career counseling session, variations of why should I be a lawyer or why are you a lawyer? I'm simply a lawyer because every once in a while I get to tell the story of impressive citizens like Vardhman Kumar. They are citizens who make countries. They are citizens who bring freedom. They are citizens who simply help us all believe that being a lawyer is really worth something. But they are also human beings who help us believe that human freedom is an ever-expanding concept, and that by doing what they do, they make the world a better place, not just for themselves, not just for everyone here, but also for folks like Arundhati and me. So Vardhman Kumar, thank you. Thank you so much for enabling us to represent you. Thank you so much for teaching us that in folks like you lies a better country. And thank you so much for that wonderful dinner that you cooked for us last night. And he also bought us each a pair of socks. I'm a sock person. So September 2018 was a special month because in September 2018, the Indian Supreme Court did something quite extraordinary. Extraordinary not just because they overturned a colonial-era sodomy statute that had been in place, since the Indian Penal Code came to be in the mid-1800s, but extraordinary also because not just that they emancipated, at conservative estimates, 140 million LGBT Indian citizens, but extraordinary also in the terms of how they did it, right? So they didn't just say, you are entitled to privacy in your bedrooms. They said, well, this is the idea of India, that the idea of India is that it is constitutional morality that prevails. It is not societal or majoritarian morality, first. It is extraordinary because they recognized that there is, in fact, a right to nonconformity, that constitutional freedoms protect ideological differences, religious differences, differences of orientation, differences really of opinion also, right? So this is really a quintessentially classic judgment because it speaks to the best of what a constitutional democracy must be and must protect. And in doing so, I think the Indian Supreme Court did something else because I think they pointed the way for other constitutional courts in other parts of the world when confronted with rising totalitarianism and fascism. How must you be a constitutional court? So the Indian Supreme Court, I think, with this decision, did so much. I think it would take more than this evening to go through the contours of that decision. And every time I read it, am I not just taken aback by the scale, the ambition, the empathy, and the lyrical quality of all four judgments written by this panel of 5 judges. But it also helps me remember extraordinary petitioners who chose to come to court after a loss in 2015 when a different panel, a smaller panel of judges upheld the sodomy law. So this was not Bowers to Lawrence, right? There wasn't this 17-year trajectory. This was Kaushal to Navteej Singh Johar, which is a very dramatic, a sort of a quick, 2.5, 3-year trajectory. But in as much as, it was a quick trajectory, it's also a decision where it took some courage for these petitioners to keep coming to court because you were still in the shadow of a recently upheld sodomy statute, which has a special bitterness to it because it's upheld by a contemporary court in contemporary times. So there are many things that set apart, I think, this judgment. Right? The other sweeping nature of the judgment included that the judgment not only found for right to privacy, but more importantly found for rights to equality, dignity, expression, and non-discrimination, apart from life and liberty. And I'm saying this because it is eventually rights to equality, non-discrimination, that take you further down that journey of full citizenship. And so I think the width of the judgment is also what makes it quite special. And finally, I just want to sort of round this off by saying that I represented this wonderful group of petitioners, 20 students and alumni of India's premier educational institution, the Indian Institute of Technology, to explain to you how smart Vardhman is. He is one of a few thousand successful applicants through a competitive exam where millions and millions of Indians apply. It is statistically the most competitive exam on the planet. And he's handsome. So the students and alumni of the Indian Institutes of Technology, and I know that there are other members of Pravriti here in this audience, and I just wanted to thank you for everything that all of you have done. You enabled us to tell a story, which was very important, because it was a story where we could very convincingly look at these judges and say, well, this is the best and brightest of India. You want these scientists to build a new country. How can they build a new country if they are fearful of loving who they love and of being who they are? It was very important to be able to tell a story about petitioners who came from every part of India, rural India and urban India, a rich India and a poor India. And India, where amongst these petitioners included folks who came from very modest backgrounds, folks who came from small town India. So it was very important because these petitioners enabled us to tell a story of a composite country of Indians who were intended to contribute by being inventors and discoverers and builders of a nation. So it is the men, the women, and the transgendered folk of Pravriti who helped us tell that compelling story. And the moment the Pravriti, which is the organization of LGBT students and alumni of the Indian Institutes of Technology, the moment they entered this battle, it became a battle of all of India and for all of India, because the Indian Institutes of Technology have a emotional, social, political, professional resonance in India which is unmatched. So to each member of Pravriti who is here today, from the entire legal team, because we didn't get a chance to meet all of you, but from the entire team of lawyers who represented you, thank you. Thank you for helping us to tell the story of what our country should become. And I will now move this on to Arundhati.
So thank you, Aya, Jane, and Professor Helfer for having us here today. Thank you very much, Vardhman, for being part of this panel. It's a pleasure to talk about this case, especially now that we've won, but also with someone who I find has so much confidence and such aspirations for your own future. I think when I come to speak at audiences like this, sometimes it's difficult to remember. I mean, I don't know how many of you actually know what life is like under a sodomy law. In 2003, I was still a law student. That's when, am I right? 2006 or 2003 is Laurence? Three is Laurence that decriminalized the sodomy law here in the United States. 1983 was Bowers v. Hardwick, which was the judgment that upheld the sodomy law here. In 1983, I was a 1-year-old. But in 2013, when the Indian Supreme Court upheld India's sodomy law, I was a lawyer. Menaka was a lawyer. We were both litigators and lawyers in that case. And at a time when LGBT people are talking about non-discrimination laws or talking where the right to marriage is under threat, I think it's especially important to think about what a sodomy law means. And simply put, even if you don't think you yourself may be arrested, there is an overarching cloud of the threat of criminalization, the threat of arrest, and the understanding that life's possibilities and life's options, the aspirations that you can have for your life, are going to be limited. The battle in India against Section 377, which was our sodomy law, was a very old and long battle. It started in the late 1990s when I was still in school. And in 2013, the case had made its way to the Supreme Court, and Menaka and I both lost that case. At that time, when we looked back to reflect on what we thought was a big gap in the litigation, what we realized was that there were no actual LGBT people in court to tell that story of what it means to live life under a sodomy law. And it can be very difficult to understand. I mean, just as perhaps today that memory is gone, thankfully, but it can be very difficult to understand or to imagine what it means to live your life, arranging your relationships, knowing that you can have no legal recognition, or choosing your job, choosing whether or not to join the civil service or to whether you want to stay in your hometown or you want to move to an urban center, really navigating your life around the fact that there is this sodomy law. So to explain that to someone, it was very important to actually have LGBT people in court telling their stories. And the way the Indian litigation had been structured to that point, we had NGOs that had moved the court because Indian standing laws and the laws that determine who can actually come to court allowed for organizations to approach and file cases before courts. And also we had parents of LGBT people, mental health practitioners, teachers, a member of parliament coming to court and talking about how they saw the sodomy law affecting people's lives, but we didn't actually have gay people speaking in their own voices and telling their story. So when Menaka and I reflected about what we thought a new round of litigation needed to do and what it needed to do differently, this to our minds was the big gap of how to tell this story in LGBT people's own voices. And in 2015, we were very, very fortunate that the first 5 petitioners came together. They were very brave. They were also a tad bit older than Vardhman. Our oldest petitioner at that time was 63, and the youngest was in their 40s. And they told a story of life lived under this law and the choices that they had been forced to make and the way they had to navigate their lives based on this law. Nafte Johar is a dancer, Sunil, and I like to take their names because I think it's really important, but Nafte Johar is a dancer, Sunil Mehra is a journalist, Amarnath is a hotelier, Ritu Dalmia is a very distinguished chef in India, and Aisha Kapoor is a businesswoman. And in fact, one of the stories that we told and that Sunil talks about is that he wanted to become a civil servant, and he cleared the preliminary exam for that, which is almost as difficult as the IIT exam, maybe not quite, but it's quite a tough exam. And he cleared that, but he decided not to go ahead with the next stages of it because he didn't think that he would be able to have a full life, to meet someone, to live with someone, if he chose that path. And by the time we got to court, he and Naftej had been together for almost 25 years. So January of 2018, the Indian Supreme Court announced that they would hear our case. And in the months that followed, there were other petitioners who came forward, including members of Pravritti, who as Menaka said, are the Pravritti is the the LGBT Student and Alum Association of the Indian Institutes of Technology. They're 350 students strong. They come from all over India, much like the student population of the IITs themselves. They speak languages from all over the country. They come from large towns and small villages. They come from all kinds of socioeconomic backgrounds. And they're young people. I think the big difference between the first case that we filed was that we filed on behalf of people who were in their 40s, in their 60s, who had made their lives work, who had successful professional careers, but who had lived under this law. And now we had the good fortune of representing these amazing young people who said, we think life owes us a lot. I mean, we deserve something from life and we have aspirations. India is a young country. Something like 60 or 65% of the Indian population is below the age of 30. So we're a very young country, and as young people, these petitioners, the median age was 24, Vardhman's age. The youngest was 19, and they said that, we are aspirational. We want to live our lives here in India. We want to be able to love who we want, marry who we want, work where we want to, and like other young Indians, we are deeply aspirational. So it was an honor and a privilege to represent them in court, to be able to tell their stories. I think it made an incredible difference to the judges who heard us, to see these young people who also came to court. Vardhman is wearing a very nice suit today. We also told them, please wear suits. Business casual is a good look when you come to court as a petitioner. And it really makes a difference to see someone, to look them in the eye and acknowledge their citizenship and their moral right to citizenship. So I will leave it at that by way of background, and Vardhman can introduce himself and maybe say a little bit about what inspired him to join this case. Like I said, Pravritti is a 350 plus member organization. There were 20 people who came forward from Pravritti to act as petitioners, because it would have been impossible for us to file for 350 people. But I will hand it over to you.
Thank you, Arundhati. Thank you, Menaka. And thanks to everybody who made this possible, who brought the three of us together again for this reunion after July 2018. That was a really dramatic day. I was in the court, and like Menaka said, I was hearing all the reasons why Section 377 should stay, as opposed to why it shouldn't. So, but at the same time, I had heard about all the arguments that Menaka had put some days earlier. I'll talk about it in a bit, but before that, I would like to introduce myself and a little bit about me. I'm Vardhman Kumar. I'm a second-year PhD student in the Biomedical Engineering Department in Dr. Shaini Varki's lab, and I work on this technology called organ-on-chips, where we try to model the human organs on tiny microfluidic chips. So the reason to do that is that a lot of drugs that we make fail in the clinical trial while they have already passed the test in animals. So one of the major reasons why is that in laboratory, when we test the drugs, we are either testing them on petri dishes or on animal models like mice, rabbits. But these are not really very representative of how human body works. That's why a lot of drugs that pass these fail in humans. So to work around that, around 10 years ago, people came up with this technology to build a fully functional human organ on a tiny chip, where you can have human cells that would work just like an organ, but it wouldn't be a substitute for an organ, but rather a model for an organ, where you can test the drugs and instead of testing them on animals. So the larger aim of this project is to build these individual organ on chips, for example, a lung on a chip, gut on a chip, eye on a chip, skin on a chip, and then to integrate them all to form a human on a chip, so that you can test drugs on these models instead of testing them on animals or directly to humans. And it would save a lot of cost and also work around all the ethical issues involved with testing drugs on animals. So I'm particularly working on a knee joint on a chip and trying to model the lung on a chip better. So that is my work here. My background is in chemical engineering. I did a chemical engineering from Indian Institute of Technology, Bombay. And I graduated in 2017, immediately after which I came to join my PhD. And while at IIT, I was very involved with Sathi. So a little bit about Sathi. So Sathi is an organization, an LGBT support group at IIT Bombay. So all these IITs, the Indian Institute of Technology, there are a number of them, and each of them have their individual LGBT support group, and the Pravritti is like an umbrella organization for all the IITs. So Pravritti started in 2012. The same year I was a freshman at IIT, and I joined the same year. And as an informal group on Facebook, it spread, the membership spread through word of mouth. People would ask other people to join this group by telling them that there's this support group that exists. And so Sathi in particular was the first. Sathi literally translates to companion in English. So Sathi was the LGBT support group of IIT Bombay. And it was founded in 2011, and it was the first LGBT support group at an educational institute in India. So in fact, in 2011, I was still preparing to get into one of the IITs, and I had heard that, okay, IIT Bombay, this one particular IIT has this organization. So I really wanted to get into IIT Bombay just so that I could be with people of my kind. I say that because preparation for IIT, the Indian Institute of Technology, to crack the exam is a very rigorous training. And my parents kept me away from internet, cable TV, everything, because they didn't want me to be distracted. So I really grew up not knowing anything about LGBT issues, queer rights, or any of those. The first time I got to know of Section 377 was in 2009, when one of the lower courts, the Delhi High Court, had struck it down, and it was in the newspapers. And that was the first time I got to know, and I was 15 at that time. So it was interesting because I got to know of the law at the same time that it was struck down by a lower court. And at the time, I was already battling an addiction to self-harm, depression, loneliness, because I didn't know anybody else like me, and I was a kid, and I didn't know who to come out to and who to explain what I was going through. So it was nice to know about the law at the same time that it was struck down. So that gave me a lot of confidence, but at the same time, I saw everybody around me, like my peers, ridiculing the fact that such a law, like now that law has been struck down. Obviously, because they were all school kids and they were insensitive. So at the same time, while I was happy that the law has been struck down, but I was at the same time also aware that I do not have to talk about my identity to anybody, because even though the law is on my side, the society in general is not. And then, but when I go to IIT Bombay for 3 years later, and I get to be in Mumbai, which is really a very diverse city. It's like a multi-city. People from all over the world are there, and it's really quite liberal in a lot of sense. And so I could connect with people like me, and because of the existence of Sathi in the campus, which was a very good support group, I got the confidence to come out within a few days of coming to Mumbai, and I came out to my family, and they were very supportive of it, which I was not expecting. But it only made me regret that I should have come out to them sooner. But at the same time, I was happy that I came out to them when I was confident about myself versus coming out to them while I was still questioning, because if that was the case, they might have tried to work around it or try to mold me in ways that I might not have wanted to get molded into. So while at IIT Bombay, as Sathi, we used to be involved in a lot of work within the campus, primarily two motives. One was to provide support to the LGBT people in the campus, and second, to raise awareness about the issues in general, folks who stay on the campus. And also, as part of that organization, we would help in organizing the Pride parades in Mumbai. Pride parades started happening in Mumbai around 2008. And from there also, we have come a long way. I think the first Pride event that happened in 2008 were attended by a few hundred people compared to like several thousand that attend now. And if we look at the videos of the first Pride marches, it's all people with masks because people really don't know what's going to happen if they put themselves out there. And now people don't wear masks unless it's part of the costume that they're wearing. So as Sathi, we used to, so now we have the entire Pride month, all the Pride events. We try to bring several of them to our campus in IIT so that like our classmates or our peers could have a look at our lives or see what really LGBT people are about versus, like I was discussing with Menaka Arundhati some time back, that in Indian society, there's a huge disconnect about LGBT people as to most of the people think those people just exist in fashion or entertainment because they see them only in these places. So by bringing these events to the campus, we wanted people around us to see how integral we are to society. We don't necessarily have to be isolated. And so then, because we were involved in these things, we always used to hear about all the events happening in the court with respect to the law. And then when I was in my sophomore year, this case came up, the 2013 case, and the sodomy law was put in place again. And that was a huge setback. And also the way the verdict was put, I think one of the most disturbing statements from the verdict was, they said that this law should be there because LGBT constitute a minuscule minority of the population. So it's like your numbers are not enough to give you rights, which was a very insulting thing, personally. So that was a very disturbing time. And also it was difficult for a lot of people because after the 2009 judgment by a lower court, there was a generation of people who had come out to their families, even though the families were not accepting, they had come out because the law was on their side. And now suddenly, with the law back in place, it had become very difficult for those people. Fortunately, it was not the case with me because I had an accepting family. But at the same time, I saw several people around me really afraid of what's going to happen now because they're out to everybody and the law is back in place. They came out in the first place because the law was struck down by the lower court. So, but that only made us more angry, more aware, rather than more fearful. I mean, I would say that was one of the turning points in my life because I started coming out after that to everybody around me. I was like, man, how can people think we are minuscule minorities? Like, we are large in numbers just because people do not know we exist around them. And one of the reasons is because not a lot of people come. So me personally, I started coming out to everybody. I encouraged everybody around me to come out and tell people that we exist, we are here, we are among you, and we are not minuscule in any way. And one, that argument is flawed. It doesn't, even if we were minuscule, you can't wait for us to be in certain numbers before you start imparting rights on us. So then after 2013, we used to follow all the court dates, what's happening or what's going around. And then finally in 2018, January, when the dates came up for the Naftage court hearing. So one of our members from Pravriti had this idea that we should file more petitions for this case to put more pressure on judiciary. And also another thing was, we thought, like Menaka said, that this petition would have a value because IITs really represent the aspiration of the middle class India, like majority, not just middle class, in fact, people from all classes, because people really think this as a staircase for a better life, for a better future, because of the opportunities that presents once you go to one of the IITs. So it'll be more impactful because it will show people that gay people are not necessarily celebrities or in fashion or in jobs that they cannot connect to. We are students. And this we are among you. And then in the then 350 member, now we have grown to around 410 members. And from among us, 20 of us came forward and were like, we would be ready to be petitioners, we would be ready to get our stories told. And the 20 of us were very diverse. We represented a spectrum of people from LGBTQ, people from diverse backgrounds, people spoke different languages. They were entrepreneurs, scientists, consultants, teachers. Across age, the youngest petitioner was 19 years old, and the oldest was in their 40s. And so the 20 of us decided to come forward and file this petition. And once we, the person who had the idea to do it, they contacted Menaka, and then the team contacted us. We put a case in a very short amount of time.
Yeah, really,
It was very tight, yeah. And then we attended the court hearings, and then the judgment came, and here we are. So that's the story. Yeah.
Do you want to ask Vardhman any questions?
Oh, yeah, we have 2,000 questions. And these are, of course, not covered by attorney-client privilege. So, the first thing that sort of I found striking about this entire petition and your group was that, and perhaps you could speak to this, that you were all so aware, and you felt, sort of as citizens, you felt you were just entitled to so much more, right? So they were extremely well organized. They were extremely aware. They really spoke a language of constitutional rights, which I was just very struck by. I speak and teach at law schools all over the country and outside the country. But here were a bunch of scientists who kind of stepped up. This petition was, folks from the tech schools. So was that striking to you at all, this kind of sense of participation in a civic sense? Did that come naturally? I mean, we talked a little bit about this yesterday. Was it something about that process of education? Was it just a set of you? I mean, what is it that created this kind of, it was like a force. They were like a force, because not only did they come to court, but they went on TV, they went on radio, they spoke in regional languages, they spoke in English, they spoke in every conceivable language that is available. We have many languages in India. They hit them all. And they moved the discussion away from just the English media to the regional media. And that was huge. It was huge to do that. So what is it about you folk? Because I find it mind-boggling.
To think of it, I'm not really sure where we got that energy from, but I'm sure there was a lot of cumulative anger that had been built up over the years, and especially seeing us progressing so well in other fields and being so archaic in this field was really making us hurt and angry. And to tell us that we don't have our rights because we are a certain way, it definitely makes you angrier than it makes you sad. Mm-hmm. And also because I would say we were also able to do that because of all the mix of talents that we have in Pravriti, because we we represent people from across cultural backgrounds, so that we were able to target the regional media based on who spoke what language. We were able to organize in that way. Also because of the different kind of professions that people were involved in. The people who were involved in journalism got the right connection so that they can help channelize the petitioners to the right source. And so I think it really comes from the diversity of the group than anything else that we were able to do so well, because we were able to use the talents that one didn't have but the other person had. And so together, I think we completed the picture, because whatever talent we needed, one of us had it. So I really think the diversity was the key. Yeah. That's good.
I actually wrote my questions down as well. So my question for you was that, as lawyers, we spend a lot of time thinking about equality and dignity. And one of the main challenges, I think, for me in working on this case was how to really make that, how to communicate that lived experience to somebody else who may have no idea what it's like to navigate your whole life under a law like this. And to communicate that in terms of constitutional values. So my question for you is, what does the Constitution mean to you, and what does citizenship mean? Because you have really changed the meaning of citizenship for so many people. The constitutional values of equality and dignity, what does that mean for you?
So I literally, I do not know the Constitution, literally, but the meaning that it would have for me is that I should not be differentiated from any other person around me for something that is so inherent to my identity, which is not to another person. I mean, I see no reason why they would enjoy a different set of rights and I would not have them, or have another set of rights just based on something that's so inherent to my identity. And similarly, citizenship also, like a full citizenship should be able to enjoy all the rights that have been imbibed to them in the Constitution. And I think that's what it means to me, to be treated just the way any other person would have been, and not to be treated differently for something that's so inherent to me. I think that's what.
Thank you.
It is for me. Yeah. Wonderful. In fact, I have a question for you too. Yeah. So I want to know what really changed from 2009, where the law was struck down by a lower court, and then 2013, where it was upheld back, and to 2018, where we got such an astounding victory. What really how were the litigations different, or what were the changes, or how did you plan things based on the things that went wrong the earlier times?
No, I think that's a really good question, Go ahead. So I think, in 2013, December is when we lost this case at the Supreme Court. And it's, one way to walk into a new year, right? We spent a lot of 2014, trying to grapple with this loss. You're right. I mean, apart from it being, just a horrible outcome, the contours of the judgment were so poor. The reasoning was poor. I think the full line is the so-called rights of a minuscule minority. And I really want to have a T-shirt made with that now. I was waiting for this to be made right before I got my T-shirt made in rainbow colors. So I think, but in so many ways it tells you where that judgment was coming from, right? This kind of animus and hostility. It's really interesting because after the judgment, I think a day or two after that, I was going for a run with a few lawyers and in this main park in the city, as one does. And the judge who wrote the judgment was walking down the story.
And he had actually retired the day he delivered the judgment.
so
so
he
he
delivered
heard
the
arguments almost a year before. Was it a year? Was it over a year?
Yeah.
It was almost a year before.
before.
He waited for a year, and he delivered. And he delivered it. I'm sorry, but he delivered it the day he retired. In India, we write day, month, year, so it was 11, 12, 13.
Yeah.
Which I will never forget. But yeah, he had by the time Menaka was jogging, he had retired.
Yeah. So, and there was so much you wanted to say. There was so much I wanted to say. But I think I kind of didn't, because I held myself back and I said, we're going to make this right. And everything I had to say, I think I was very clear that I would say in a court of law, and we would make this right. So I think it took us a few months to wrap our heads around the laws. And then I think by the end of the year 2014, we kind of, you need some time to separate yourself from, a case that you care about that you've lost. And, but it gave us some time to reflect. You're right. I think the predominant emotion is anger. Not grief. First there's grief, but then it quickly turns to anger. And the wonderful thing about, I think, being a lawyer is you can actually do something constructive with that anger. So I think that we reflected on, well, what would we change, in terms of a litigation strategy? You can't always change the outcome. You can have a good case, a good strategy, and yet lose. But what you can change is only the things that are in your control, like the litigation strategy. And this strategy, I think, of having institutions and not people, has its shortcomings. And the shortcomings are you don't have life stories to tell. You don't have petitioners to present in court. You don't have the ability to say, here are the best and brightest of India. These are 20 petitioners who are students and alumni of the Indian Institutes of Technology. They are super successful. They are the best and brightest. They would like to do X, Y, Z. And why is it then, when I look at the affidavits that they filed and the questionnaires that they filled, that there are these rates of depression? Institutions don't give you the ability to make that argument. It is human beings and human life that gives you the ability to do that. And courtrooms are arenas of storytelling. If you want to change laws and you want to change the minds of judges, you have to be able to humanize your client. And so I think the big difference is from 2013, when we were younger lawyers, to 2018, when we had filed cases and we made these decisions. But I think in 2015, when Arundhati and I sat down with the first set of petitioners, and we had met at a small breakfast shop in Delhi, and we said, well, we think we should go to court with real life petitioners, and they said yes. The thing is that you had so little to offer any petitioner after this loss in 2013. You couldn't promise them that you wouldn't lose again. You couldn't promise them that crazy people wouldn't show up at their doorstep. You couldn't promise them that their professional and personal lives wouldn't be destroyed, or that their professional and personal reputations wouldn't be destroyed. You actually could not promise, you can never promise a client anything when you've lost so recently. So I think that this big jump in litigation strategy to actually having real, live LGBT Indians was important. It was high risk, and I think we spent, innumerable kind of sleepless nights wondering what would happen if we lost. But we were convinced that it was so important to humanize who is an LGBT Indian, because in the last set of arguments, there was a question that the judge who wrote that judgment asked the courtroom. He asked the additional Solicitor General who appeared in the hearings in 2012, well, do you know, he said to this gentleman, well, do you know any gay people, right? And that question was never answered correctly, because the additional Solicitor General said, no, my lord, I don't live that kind of life. Ha ha. And that was very much this idea of the so-called rights of this minuscule minority. It comes from, many things. We expect judges to do better. It doesn't matter as a judge whether you know someone or the community that person comes to. That is why you are an adjudicator, because you must be able to transcend and you must be able to interpret a constitution with conscience and empathy. But be that as it may, that you will have these shortcomings as a judge. The fact is that that question was not answered. And no amount of media coverage, could have bridged the gap that is always there in a case like this, which is a social values case. It is about changing mindset. You cannot do that without having petitioners in court telling these stories, telling your story. That is how you win. That is how you make change. So I think that that's the big difference that, you see in these years. And I think the next big difference that you will see is that from now on, LGBT Indians will go to their courts. They will go to lower courts, they will go to the apex court, and they will speak in their own names and in their own voices, and they will not in future have institutions speaking for them.
Well, with that just extraordinary set of remarks, I think that's a perfect segue to open up for questions. So please raise your hands. I may take 2 or 3 and then have the panelists come back depending on how many there are. So please, the floor is open. Okay, 1, 2. Anyone on this side want a question as well? Maybe we'll take 3. Yeah, okay, so let's take 3 and then we'll have some responses. Please.
Questions for Vardhman. So you talked about your group going to the media and kind of speaking out. What was it like after you joined the litigation? What kind of public reaction did you receive, or reaction in the media?
So interestingly, when we were planning to file a petition, a lot of us were very apprehensive, or I shouldn't say apprehensive, but uncertain as to what might happen. We didn't know how much will it blow up, what's going to happen, who's going to, like Menaka said, show up at our doors, and if for any reason we were not going to win the case, our identities would be out in the public and we would be vulnerable to persecution. So definitely, initially we were apprehensive, but then for some reason, because together combined, all of our strength combined, there was always somebody to encourage us to come forward to talk. And so when this thing came out in the media, it was like the same day that our petition got accepted to hearing, like all the newspapers was flooded with, obviously IIT was in the headline that 20 students from IIT file a petition. So that's what made the headlines, everybody saying that students from IIT have petitioned in the Supreme Court to get rid of this law. But I also read a lot of media coverage which spoke of more detail as to how this petition is important, because this represents people who belong in an area where much larger population can relate to. Like I said, IIT being then the aspiration of the middle class country, the middle class India. So people were more able to relate, oh, these are the colleges that my kids go to, or these are the colleges that I would want my kids go to. And these places also have gays. So gays don't necessarily just have to be in fashion, but they can be engineers, entrepreneurs, professors, teachers, scientists, all of those. So I think that was the kind of coverage that I read. And at no point there was any negative coverage. I think media has been really helpful in that case for us. And
very much.
And with this, obviously, they got a very wide readership because of the IIT, so it was covered a lot. Yeah.
So let's take the other 2 questions and then have the panelists respond.
Thank you for coming to Duke and sharing your stories with us. My question is whether you're following or have any thoughts on other pending litigation in different jurisdictions which follow the Indian Penal Code. Specifically, I'm interested in Singapore.
Okay, and one more, and then I'll let you respond. We had, okay, please,
I'm just curious what the reaction within Indian society was like, particularly after the 2013 decision, and then after this most recent decision. What was the difference, and where do you see it going forward from here?
Yeah, I'll take the second question, and you can take the Singapore question. I actually think losing in 2013 turned out to, it was very difficult, but it turned out to be a blessing in disguise, I think. Because if we had won, it would have been like business as usual. People can just keep on living their lives. They can stay in the closet if they want to, because things are okay. But because we lost, it was like you had nothing left to lose now. So things actually changed a lot with many people coming out in the media and, writing stories of violence that they had faced, that they were unable to report to the police because there was a sodomy law, or simply, the choices that they made. There's a very famous, iconic kind of magazine cover of a famous writer, Vikram Seth, who's dressed like a prisoner behind bars, saying, "I'm a criminal," and his mother was a chief justice of a high court, and said, wrote in the papers that the judgment lacked empathy, which is a crucial quality for a judge. So I think all of these responses would have not been seen if we had had a victory. To the rest of your question, I think one key difference between the Indian Supreme Court and the US Supreme Court, for example, is that the Indian Supreme Court has been at the forefront of social change. Whereas when you compare that to the US litigation, especially on same-sex rights, the court has acted when it senses that society has already changed. So with Obergefell, for instance, there were n number of states that had already passed laws adopting same-sex marriage, and then the Supreme Court, passes its judgment. Or even with Bowers, and when you compare Bowers and Lawrence, there's a 17-year gap between the two, and by the time Lawrence comes around, there are very few states at that time that still have sodomy laws on their books. So what I do believe is that, one, you have this court which, because of the way the Constitution is framed, takes that position, pushing society to change also. But I also think that, for LGBT people, for other minorities, and historically disadvantaged groups that are protected by the Indian Constitution, it's very important to know that their court speaks for them, and that the change that they bring about, because their lives change and because they have the confidence to go forward as changed citizens, as citizens who now have the confidence to participate in civic society, in government, and to move their court and to act as petitioners. That change is immense. I mean, the LGBT population in India is 140 million people. It is the second largest, a kind of rough estimate places LGBT people as the second largest minority in India. So for that population to change is itself a harbinger of great social change.
So one of the sort of one of the wonderful things about this judgment has been what it's meant, in a sort of as a shooting star or whatever, not in any kind of way to be a precedent in other jurisdictions. One of the things that happened after Navdeep Singh Johar was delivered is that a few days after, a challenge was filed to 377A in Singapore. So these are all colonial laws, except Singapore is a modified law, as you know. And then a few weeks after that, the Kenyan High Court, that had reserved judgment on its sort of constitutional challenge, made it a point to take this judgment on the record, and said that they were taking this judgment on the record, so the judges would consider it. There are cases, claims, and cases which are brewing in multiple jurisdictions right now. So we hope that in some ways other judges will at least give this judgment a read. That I think the Indian Supreme Court is really a trailblazing court per se, but is also a deeply influential court in the global south, is also very, very important. Its jurisprudence in so many ways, navigates both the cultural richness of much of kind of the demographics of many, many other countries in the global south. So I do know that for many Supreme Courts and High Courts in the global south, in Asia and in Africa, the Indian Supreme Court is looked to. So therefore, it gives me hope, for other jurisdictions. And right now, there are 2 cases pending in Singapore. There's a second petition that has been filed. And it was wonderful because we've actually now, in the last few months, been meeting some of the other lawyers, and they're just, it's quite terrific to see the energy.
Let's take another round of questions if we have them. 1, 2, one more. Oh, yeah, 3. Okay. So, sorry, I lost track. And then we'll do one. We should have time for one more. Karen, who was first? I can't remember. I think. Yeah. And let's take all 3 and then have the panelists respond, please.
Hi. As you mentioned that there was a very short gap between Kaushal in 2013 and Navdeep Johar in 2018. Do you think that this judgment is here to stay, or do you believe that it is at the mercy of the current composition of the Supreme Court?
Good question. Yeah.
You spoke about 2013 judgment. I know the judges were against it, like they lacked empathy, as you said. But within the realm of the your profession, did you see your peers like accepting this?
Did you see your peers?
Your peers or subordinates like accepting this?
Very good question.
Acknowledging them.
Yeah.
Leaving aside the society. But,
Sure. Sure.
And another question, can I speak?
Yes, of
Yeah, please.
So, what was your reaction when you got to know about that Praviti members are petitioning?
Yeah. Yes. Great. 2 great.
And one more. And Gustavo, do you want to? Okay, we can do one more for this.
It's really just to get your reactions when you read the decision, like that first minute. Like what does that feel like as an attorney, as a petitioner? Where were you? Can you paint that picture for us a little bit?
Whichever one you want to start, however you want to.
Sure. So maybe start with this, and then I'll you can take the rest. So as you know, so thank you for your question. You must be an Indian lawyer. So this is a 5-judge panel. As you know, a constitution bench. These are not constituted often. I think it's a very strong set of judgments. There were 4 judgments written by, the Chief Justice wrote for himself and a brother judge, and then 3 other judgments. And they're very, very strong, elaborate judgments. So I think, with all humility, I don't see this decision being overturned both for structural reasons, in terms of that it's a constitutional bench decision, but also I think because the reasoning draws on a line of judgments from past benches. So in as much as obviously, much has been made of the International and Comparative Law that the judgment does kind of consider, I think the heart of the judgment is that it, multiple judges navigate a kind of a constitutional arc. So they look to judgments which protect intercaste relationships, interreligious relationships, and then sort of arrive at this. So that's the first thing. I think the second thing is this idea, I think, which has come to be of constitutional morality. It's a very powerful, constitutional philosophy because I think it navigates so many minorities. that to have this judgment located in that is extremely important because it locates, I think, LGBT Indians with other minorities in India and locates their sort of dignity, equality, non-discrimination rights with that. And so therefore, I think to strike this down, you would have to strike that entire jurisprudential arc down. You would have to strike down multiple benches, which don't see happening. This is not to say that, that change is always positive or one way. I'm not making that case. I just look at America. And you are going to have battles here. You are going to have battles here to ensure that a Bergfell is not bled out through small cuts. So I don't think Lawrence is in danger, but a Bergfell may be bled out through small cuts. So I think that, you have to be vigilant to maintain change. And I think that is something that we have learned from this contemporary political movement across the world, that constitutional democracy is not to be taken for granted, that you have to fight for it through movements and court cases and multiple other ways that we all kind of need to work hard to defend constitutional democracy across jurisdictions. That's the point, right? I think the point of this decision is that it speaks to how you safeguard constitutional democracy to other jurisdictions as well. This is not, to my mind, this is not just a case about a sodomy law. This is a case about freedom. And that's why I don't see it being struck down in the near future.
Arundhati.
So I'll respond to your questions. What was our reaction when Pravritti approached us? I mean, naturally we saw the potential of this case and the story that could be told. But I think more than that, I was just astounded that there was this organization that had 350 people from the Indian Institutes of Technology and which had been functioning for so long, because I can say that, the law school, the law schools did not have, societies like this when I went to law school. I still don't think that Indian law schools have a kind of unified umbrella organization, even if there are student support groups. And so, we think that the place where you will find constitutionalism and, and I know that this is a mixed crowd with students from Pratt, am I right?
Pratt, yeah.
Pratt, yeah, so hey. But you'd expect that arguments about constitutionalism or some civic engagement through approaching the courts, you might expect it in law schools, but it was wonderful to find that here were these stellar tech schools where the students were so engaged, or even the alum are also really young alum who filed these who filed this case, who was so engaged, who were ready to make citizenship claims, and who clearly articulated, their experiences as gay people in terms of citizenship, like exactly what Vardhman just said, that, here I am, this is an intrinsic quality, I am just like any other citizen, and I deserve the full spectrum of citizenship rights.
But also, I mean, this is all true, and this is a very elegant, lawyerly way of putting it. But the other part of it was when I got this call saying that there's Pravritti, and sort of the voice on the other end said, oh, and we're 350 people, and I said, what? And he said, we're 350 people. And so eventually, a few minutes later, when I told Arundhati, I was like, Pravritti, which is a pan-IIT LGBT organization, wants to challenge the law. And she was like, IIT. And then I said, yeah, there are 350 people. And she said, 35? So I said, no, 350 people. And then, I did this little jig, which, I can't do, because I think at that moment, you knew you knew, and you just instinctively knew, not just as lawyers, but as Indians, you knew what this petition would mean.
Yeah.
I can show you the jig later. So I think it was just, it was dramatic. So yeah, it was just a very, very important intervention because exactly what Vardhman said, it has changed the perception of who is gay in India. And that's what it's done.
Vardhman, do you want to maybe,
Yeah,
I don't know,
I think
where
so.
were you when the judgment
Yes, yes.
came down?
Yes.
And what was your first thought when you heard that you had
Yeah.
won? And so resoundingly, too.
So I think I was here, in fact, when the judgment had come. I was about to come, and late night I was planning to be up all night because that time it's morning in India. And I thought that I'll be up all night, I'll get to know the decision, and then I'll go to sleep. But somehow I crashed. But I woke up and I was flooded with messages and all the news alerts, and then I found out that this has happened, and I was kind of sad. I was like, I wish I was there. I wish I was at the Supreme Court or among my friends back in India so that I could celebrate with them. Instead, here I am about to get ready to go to my lab, and yeah, but I was really happy, and I came to lab, and my professor congratulated me. My colleagues who were sitting here congratulated me. And friends from India congratulated me, and Robert, my roommate, congratulated me. I got back home, and I baked rainbow muffins.
Nice.
And yeah, that's what I did. And it's
Great.
Yeah.
Wonderful. I think we have time for probably one more set of questions. So maybe I'm going to try to get as many in. 1, 2, 3. Is there a fourth? If there is, we'll take it. Okay, 1, 2, 3. I don't know who's first. Go ahead, Anna, please.
Well, thank you for being here. This has been an incredible experience. My question is, of course, this was an incredible landmark decision, but what's next? So in terms of LGBT rights in India, of course, this is a great start, but I'm sure there's still a lot of systemic issues in place, societal stigmas, et cetera. And so both in terms of personal passion, of course, there's a lot of energy from the youth and the community. So in terms of your own personal experience and your friends, what's next for you guys on the agenda? And as lawyers also, what's next to fight for?
Mm-hmm. Great. Doesn't matter.
That was my question, so I'll just say thank you for coming and talking.
Yeah, over here. In the green.
So first, thank you all. I really appreciated this, and this has been amazing. So my question is kind of along the lines of you all mentioning how Pravriti joining this effort acted as a major catalyst in influencing the decision in India. So obviously an organization like Pravriti has a lot of agency coming from top tier institution in India, the best institutions in India. So what kind of legal initiatives can you imagine having to protect maybe more someone from, let's say, a rural setting in India, to ensure their protection as well, because they might not have the same agency or power that such a large group might have.
I think it was the same question. Unless there was a fourth?
One more question.
Yeah, there was a fourth question.
Did I miss someone? Yeah, please. Hard to see. Thank you.
Thank you. I just wanted we sometimes study how our courts rely on the opinions of the courts internationally, and I was wondering if at any point did the Indian Supreme Court rely on Lawrence or any of
Yeah.
Yeah, good question. All good questions.
Yeah.
Yeah, go ahead. So, you want to start? No, go for it.
I was just answering your question for what's next. Well, while we are right now still absorbing the fact that we are there, we reached where we have wanted to for a long time. So we haven't really put very focused or channelized thoughts into where we want to go next. But at the same time, it's important, like also it was said in the judgment by the judges, that the government should advertise this verdict more to the common people so that people can get to know about this and get to know. And so personally, for me, now I feel like a lot more opportunities have opened up for me in India, which I would have been apprehensive to take up, fearing backlash, fearing persecution because of the law. So personally, a lot more opportunities have opened up. And also, I think because of this judgment, more people will come out, more people will get visibility, people will get to know how we are part of the society in ways that they did not think. So I think next for us is to get more visibility, get people to understand the importance of this verdict, what this means in terms of societal changes.
Yeah. I think that, to your question, I think that one of the decisions we made as a litigation strategy and as an argument strategy was that, obviously we submitted briefs which had a fair amount of international and comparative law. But in court, the strategy we adopted was that we looked to international and comparative law, which relied on the Indian Supreme Court's decisions. So we flipped it. And in doing so, why did we do so? And this was really Arundhati's idea. We did so because, as she rightly said, that, we needed to tell them that, when you give a decision, it is relied on by many global courts. The usual suspects, of course, we found Canadian decisions and so on, and Australian decisions, but we also found Kenyan decisions, and we also found, decisions from Trinidad and Tobago, where the previous decision, for instance, Kaushal, which we lost, was relied on by attorney generals in other jurisdictions to argue for upholding their own sodomy law. So I think, and I open my arguments by telling the court this, that you are relied on in multiple jurisdictions. And it is my hope that, in the future, when arguments are presented in other courts for freedom, for dignity, for equality, they will look to Navdeep Singh Johar and cite you. So I think that we flipped that argument around because so much of, and as someone who does comparative constitutional law also, so much of the imagination of these discourses, right, comparative constitutional law, international human rights law, is so located in the global West, right? It is so located in the American courts and Canadian courts and so on and so forth. But in the global South, courts are looking to each other. They're looking to South Africa, they're looking to India, they're looking to Colombia. I've just come from Bogota. Hola. There you go. So I've just come from Bogota, where constitutional law is so different. It means so much more, the Constitutional Court. I was speaking at a conference where, a conference that started at 7:30 in the morning, there were 1,500 people in the hall. Law students, scholars, thinkers, writers, common citizens. And there were 2,000 people outside the hall who couldn't get into the hall. And we were just talking constitutional law. So much of the problem is also that our imagination in terms of disciplines is so located in the global North, where so much is failing right now. I don't think the question is Lawrence being cited? I think the question is, why doesn't the American Supreme Court look outwards? Right? And what is going to happen to this American Supreme Court now with the change in composition? And what will happen if one of my most favorite judges, doesn't even need to be said, So I think that time of citing Lawrence is over. I'm very happy to say that. You get the tough question.
Yeah. The students and alum of Pravritti were privileged in the sense that they had this incredible education to back them, right? But and they came to court, and they came to court also knowing that they were enabling us to tell this story about being, in some ways, the Indian dream. But I think that there are a lot of people who come to court. And what we're actually seeing is that, LGBT people are already coming to court. I mean, we've had something like 4 high court level litigations already, which is just, there are a lot of cases that get filed. And one of the analogies that we drew in the petition was to interfaith and intercaste couples whose parents may not have accepted their relationships or in many cases their marriages, and who then prosecuted one of the partners typically for kidnapping offenses. And what you're now seeing is that similar cases are being filed against same-sex couples, and which may or may not be a good thing, but same-sex couples are taking recourse to the law, to appellate courts and writ courts for the same protections that opposite-sex couples are entitled to, and they are receiving those protections from the court, where there's a case that's been filed in Delhi, there are cases that have been filed in other parts of the country. So I think that sense of being constitutionally protected citizens, once rights are available to you and once you know that your courts are there to protect you and that they have your back, people are coming to court from all sections of society.
So I want to take the prerogative of the moderator and maybe enrich the discussion a little bit, because there were certain things I heard here that resonated very deeply with some of the trajectory of the LGBT rights litigation in the United States. So the first thing I wanted to say is that, sometimes a loss can be ultimately a more secure victory. Yep. So just to see how that works in a particular context. So I had not yet started law school when Bowers and Hardwick had been decided, and that was nevertheless a really terrible loss at a particular moment in time when the gay community in particular in the United States was really suffering and dying, and the confluence of the HIV/AIDS crisis and the fact that this judgment had come so close and then went the other way, again with an insulting concurring opinion by the then Chief Justice Berger, and really not taken seriously. And indeed, a similar story to the one you told, Justice Powell kind of is reported to have asked in his, does anyone know a homosexual? And one of his clerks was gay, but was not open about it. And later, the force of that judgment, combined with other social forces, caused people to have to rethink what their strategy would be, to go back to state legislatures and state courts and begin to mobilize not just through law, but through social action and through, the imperative of being open about who you were. And then I also had the privilege or misfortune or both of being in the audience at NYU Law School when Justice Powell was asked, when I was a law student at NYU, what he regretted. I won't get the question exactly right. And he said, well, in the Hardwick case with the reflection of time, this is after he had retired, I think I got that wrong. And I couldn't decide whether I wanted to hug him or hit him, because it was such, a moment of, missed opportunity. And indeed, in Hardwick, to sort of close the circle on citing a foreign and international law, the European Court of Human Rights decisions were not properly cited. They were, not understood. There was a citation in one of the briefs to an earlier commission decision. It was really not briefed in a way that would have allowed any of the justices to say, as they did, that if we ruled the other way, it would cast aside millennia of moral teaching. So when Lawrence cites to the brief of the High Commissioner of Human Rights, when Lawrence cites to the European Court of Human Rights judgments, that's a vindication of a kind of constitutional discourse. And I agree with Menaka that I don't know what that means for us now in the United States. Because guess what? It used to be that the United States Supreme Court was always cited in other judgments in the global north and to the extent they did in the global south. We are cutting ourselves off from that conversation. Yeah. And it will be courts like the Supreme Court of India, like the Constitutional Court of South Africa, like the Constitutional Court of Colombia, and others in the global south that not just on this issue, but on a range of individual and fundamental rights issues are going to take the lead. And one can only hope, to circle back and conclude here, that, you don't measure success in a day or in a year or maybe even in 5 years. I mean, this is a very short time period you're describing. There is a discourse that will continue, and even if it ebbs in the United States, it's going to flow elsewhere. And eventually, it's going to come around. So in the trajectory of your careers, you will have an opportunity to see over the course of time how that flow actually comes about and how you can participate in how that happens. So with that, I would like you to join me in thanking our panelists and to meet us outside for the reception.